Labor's revised list requires the court only to consider the benefit of a child, quote, being able to have a relationship with the child's parents and other people who are significant to the child where it's safe to do so. However, the list does not require the court to consider whether the benefits of a meaningful relationship, as is presently the case. The word meaningful has been entirely removed. The term meaningful itself requires careful definition, but at least signals that the Australian legal system recognises that it is important, indeed vital, for children to have a meaningful relationship with both parents. Labor's amendment seems destined to lessen the importance of that, and I suspect it will make it even more difficult for fathers to have meaningful relationships with their children when families break down, as is presently the case. A supervised visit once a month might be a relationship, but it seems that it would fall short of the test of enduring a meaningful relationship. Again, this is complicated and perhaps somewhat semantic, but why the change? Relationships with grandparents, aunties and uncles, cousins or step-siblings may be of great importance to children, and with this amendment, the court need not consider the benefits of a meaningful relationship with those people, only the benefits of a relationship. Labor are essentially lessening the significance of family relations in this bill at a time when many Australians feel the family is already under attack and being undermined. Furthermore, the most significant part of Schedule 1 would repeal the presumption of equal shared parental responsibility that applies when courts make parenting orders. And some history is needed here. The introduction of that presumption was a triumph of bipartisanship and sensible reform under the Howard government. Prior to 2003, there was widespread concern about how courts dealt with contact and residency issues for children after a relationship had broken down following a divorce. The way the courts approached those issues left many parents feeling excluded from their children's lives after separation, and it often resulted in the debate turning away from the benefits that children derive from a positive and caring relationship with both mother and father, and instead focused on arguments concerning having children having equal time with each parent, which is not necessarily the same thing as any child of a divorce would tell us. Against that backdrop, Prime Minister Howard commissioned an inquiry into the family law system, which resulted in the landmark report titled "Every Picture Tells a Story." That report was a great accomplishment, and its recommendations were unanimous and bipartisan. The Liberal and Labor parties joined together to work through a complex and important issue, relying on moral principles and common sense as their guide. Their recommendations were given effect by changes to the Family Law Act passed in 2006 under the Howard government. Now, among other things, those reforms said the courts must apply a presumption that it's in the best interests of the child for there to be equal and shared parental responsibility. This bill removes many of those guide rails that were introduced in 2006, contrary to the recommendations of the ALRC. Now, the ALRC said that it, quote, supports the idea that a presumption of shared parental responsibility serves as a good starting point for negotiations between parents and recommends that concept be retained. A child might spend a week at their mother's house and a week at their father's house, but this doesn't mean that both parents are sharing equal responsibility or jointly making major decisions. In classic Labor fashion, their amendment goes much further than what's been recommended and entirely misses the point. The ALRC's recommendations are clear. The presumption should be reformed and it should be clarified. We therefore lose a clear statement of the law saying that it's in a child's interests for its parents to cooperate and agree about how best to raise their child. For very many parents who negotiate in the shadow of the law without lawyers or courts, this is a profoundly damaging change. The genuine best interests of Australian children must be provided for, but Labor has taken a heavy-handed, sloppy approach that will do harm to children and to parents experiencing the awful trauma of family breakdown and divorce.